Mr. Chief Justice, members of the court, good afternoon. My name is Wade McCann, and I represent Kameron, Leo, Kilgo. It's my understanding, first of all, I'd like to reserve a couple of minutes of my time if I could, and I will manage my time as best as I can.
Good luck with that.
Thank you. It's my understanding of today's proceedings that the court is allowing oral argument in order to address whether leave to appeal might be granted. Appellant seeks leave to appeal.
That's not the only option that we have.
sorry?
That's not the only option we have. We can take any action we want, so make that.
Understood. I'll keep that in mind, Your Honor. Appellant seeks leave to appeal after a denial of his motion to allow the defense of a reasonable mistake of age from the Third Circuit Court in a criminal sexual conduct third-degree case. That was pursuant, that order was pursuant to People v. Cash at 419 Michigan 230, a 1984 case. A stay was granted for this interlocutory appeal, which brings us here. Now, it's been nearly 32 years since Cash was decided, and there's a significant change in the landscape since that time. Cash relied on People v. Gingles at 218 Michigan 362, a 1922 case, and it's the position of appellant that neither Cash nor Gingles are viable if they ever were. Both cases require a presumption that where the legislature is silent regarding intent, the court must presume that mens rea is not an element. Further, the Cash court states that the trial court, in fashioning a sentence, can consider mitigating factors, which would allow them to take a less culpable defendant and give a lighter sentence. However, with the Sex Offender Registration Act at 28.721, which came into effect after Cash was decided, that's no longer the case, and the trial court has no authority to mitigate the effects of the Sex Offender Registration Act. In 2015, the Supreme Court of the United States decided Alonis versus United States at 135 Supreme Court 2001. The court said in Alonis that where the statute doesn't specify a mental state, that it will not assume that one does not exist. Further, the court said that mere omission of any mention of criminal intent should not be read as dispensing with it.
Counsel, so it's true, there are all sorts of cases from the U.S. Supreme Court, like Morissette, that say that we generally disfavor statutes that don't have a mens rea requirement, but the textbook example, counterexample in all those cases, including Morissette itself, is exactly the circumstances here, statutory rape. So how do you get around that?
Well, I guess, first of all, I would disagree to some extent respectfully that Morissette stands for that proposition.
You deny that Morissette mentions
No.
statutory rape as an exception to the general rule, they state?
No, I don't deny that.
Okay, well then I don't understand the predicate for your answer.
Okay. Morissette in dicta indicates that while not relevant to that case, that the common law did treat statutory rape by not allowing the defense of reasonable mistake of age. Right. And they go on in a footnote, footnote 8, to describe that fact and to describe how it was treated. But that, I don't believe that was the holding in Morissette or what the case stood for.
Okay.
Okay.
So it wasn't the holding. It was just an expostulation that we are aware that there are exceptions.
Exactly. That's our
They
position.
did that in, what's the sodomy, New Texas sodomy case?
I'm sorry?
Lawrence.
Lawrence.
They did that in Lawrence as well.
Yes.
So, not a holding, but a recognition.
A recognition that that's the way it's been treated. And
Well, but then what you're asking us, notwithstanding the Supreme Court has serially acknowledged this exception to the imputation of an intent requirement where none is specified, we are to assume that their cases require us to extinguish the exception. That's the argument you're making here, right?
well, I guess I would go back and pursuant to English common law and say that this, this exception, it never existed originally in the common law that was brought over from England. If you go back, all the way back to the 12th century on up to modern times, in England they've always allowed the defense of reasonable mistake of age.
Yeah, but we haven't in the United States.
That's-
so I
That's
guess I don't
true.
understand.
I was
So
just
we're
trying to get,
apostate as to the English common law. But our common law has always recognized there is no defense.
and I think that I just wanted to bring up that issue, not that the court would rely on that necessarily, but in 1875, Regina versus Prince comes along at Law Report's Second Crown Case Reserve 154, an 1875 case. That was an abduction case. And in that case, a girl lied about her age, and she was abducted from her home, and she claimed to be 18, and she was only 14. And the court found that the wrongful act occurred in the abduction, so they didn't allow the defense that he believed her when she told him that she was 18 years old.
What about
So but the court didn't allow that defense, and then the courts in the United States used that, even though that case was overturned within
Got it.
10 years.
We just messed it up. We just didn't understand what the English were doing, but we have uniformly, I think you would say, in the United States, except where, in the instances where the legislatures of several states have done so, and one or two jurisdictions where the court took it on, the common law has been that there is no defense of mistake to what used to be called statutory rape, which is now well, it used to be rape, but common law rape, but now statutory rape. Isn't that right?
In most jurisdictions, that's true.
And in this one, too?
Correct, Your Honor.
Okay.
But counsel, even more so, it's not merely the common law that stands for that proposition, but as a result of Cash, it's also the statutory law of the state that's been interpreted not to provide for such an exception. So in light of that, what can this court do?
Well,
In other words, you say that there's significant changes in the landscape, and perhaps that's true, but are they significant changes in the landscape that should be called to the attention of this branch or to the attention of the legislature, whose previous product has already been interpreted by this court as lacking a mistake of age exception?
well, because this is a common law crime taken over from England,
It's now statutory.
I understand.
That's the point he's making. We interpreted in Cash the statute, not the common law.
Well, but Cash relied on Gingles, and Cash even admitted in the opinion that Gingles did not squarely address the issue of constitutionality of whether or not the defense of reasonable mistake of age should have been allowed. And in Gingles, the case didn't really, it was based on prosecutorial misconduct was the ruling, and they, once again, in dicta, mentioned that the defense of reasonable mistake of age is no.
So,
Counsel,
counsel,
just
what if-
to-
oh, go ahead.
No, after you.
What if we agreed that we were wrong in Cash? We got that one wrong, but we got it wrong 32 years ago. So what should we do about it now? It's an interpretation of a statute. We'd have to overrule that interpretation, and then shouldn't you be talking to us about stare decisis? Like, just because we're assuming that we were wrong, even if we were wrong, that doesn't mean we overturn a holding. There has to be more to it than that.
I guess I think that when the Supreme Court of the United States says that there's a presumption that when there's an omission of any mention of criminal intent, it should be read as it shouldn't be read as dispensing with that intent. I think that the Supreme Court's giving direction as to how these statutes should be interpreted, and
But that only, again, goes to whether we were wrong in Cash. But just because we're wrong doesn't mean we're going to overrule the precedent, right? That's the doctrine of stare decisis. You stick to the thing decided unless there's a good reason to fix it. So what's the good reason to fix it here?
You think it's unconstitutional. You're arguing it's unconstitutional.
It is, Your Honor.
What's your best SCOTUS case that indicates that our cash decision is unconstitutional?
I guess aloneness is certainly important. Excitement video at 513 U.S. 64, 1994 case indicates that Morissette, reinforced by Staples, interprets that the presumption in favor of a scienter requirement.
That only goes to statutory interpretation.
Yeah, can I start on the can I follow up on the constitutional piece of this?
Yeah.
Would you concede the AG's point that not a single court in the country has held it unconstitutional to prevent a defendant from raising a mistake of age case, a mistake of age defense under these circumstances?
I would not. The state of Alaska versus Fremgen, they
under the federal constitution. I said under the federal constitution.
Well, they do say in the case that not allowing defense would violate due process as a deprivation of liberty. So presumably, if that's the basis,
it was under the Alaska Constitution, though. And so, and I mean, I couldn't. I think the AG got that one right in that representation about the law. So for us to trailblaze might be an uphill battle for you. But you did argue. I mean, at least you, I think, had a subtitle in your brief somewhere that you thought maybe it violated our state constitution as well, which is how Alaska got there. But I didn't see any argument on that in your briefing. Do you have any argument on why the Michigan Constitution would require more process or different process than the federal constitution on this issue?
I don't know that it would require more than the federal constitution. I think it's basically the same issue, the violation of due process through the deprivation of liberty, and that was by extension the approach we were going with.
Well, I not only didn't see any argument, as Justice McCormick has indicated, to the Michigan Constitution, but I don't recall having seen even any reference to such cases in Michigan as Toombs, which address this issue. Neither Michigan case law nor the Michigan Constitution seem to play much of a role in your brief. Is that fair to say?
I think that's fair. There weren't many Michigan cases cited.
Oh, there is. He just mentioned one. Are you familiar with Toombs?
With Toombs?
Yes.
I'm not familiar with that case, John.
No, it's like Morissette, right? You're wrong, but it was.
He was right.
He was right. Don't worry.
It's 2-1. I'm still right.
Counsel, if I could maybe just follow up on some of the discussion that's been happening. I think one of the big questions that I think people are having is, why is this not an issue for the legislature?
You know, I think it could be addressed with the legislature.
Why shouldn't it be? That's the question. Why is this a third branch question at this point?
Yes, our belief is that this was judicially created and it could be judicially modified. That this was originally at common law. It was a defense to allow reasonable mistake of age, and as we alluded to, that at some point got changed, and many jurisdictions started not allowing the defense and treating this as strict liability.
Have you got any American case at or after our founding that said the common law rape of an underage child permitted the defense of mistake? One?
That actually, that information came from an article in the Michigan Law Review. Reasonable mistake of age.
They've got a law review?
I'm sorry.
Sorry, I was just surprised.
Yeah, that was by Larry Myers at 64 Michigan Law Review 105.
What's the common law case in the United States that recognizes the defense that you seek here?
I don't know that there is one in the United States.
That's my point.
I'm sorry, missed that question.
Anything else?
No, nothing else, John.
Thank you.
Good afternoon. Tim Boffman, Assistant Prosecuting Attorney, representing Kim Worthy, the Wayne County Prosecutor, and the people who are the appellee in this matter. As this court has noted, People v. Cash was decided almost 32 years ago now. I believe it was correct when decided, and that nothing in the jurisprudential development in the country calls it into question. I could stand here and read from it to you, but I think you're all familiar with it. I'll stand for questions. I believe Cash was correct when decided, is correct now, and leave should simply be denied so this case can go to trial or a plea can be taken, whichever the defendant chooses.
Are you troubled at all by this case?
No.
Why is that?
Well,
What should the defendant have done here to avoid having entwined himself in this law?
I think we have to be careful here in part because there really are no facts yet in this case. There's been no preliminary exam. There's been no trial. The facts that are discussed, and I appreciate the Attorney General discussing them in the amicus brief, are all from the investigator's report, but we really haven't got anything on the record yet that's evidence in this case. But we have a 27-year-old in the investigator's report, a 15-year-old, supplying vodka and other, that doesn't trouble me. If there are cases that trouble me, and perhaps there could be, then one should go to the legislature and say, maybe we should do something different here.
Counsel, good afternoon, and I just really want to follow up on Justice Markman's, question. I mean, ultimately, the goal here is to promulgate the law. So, what's our takeaway? What is it that you want the people from Michigan to take from this case? And if we were to look at the facts of this case, you have an adult who looks like he did everything he could to avoid this situation from happening. It was a website that catered to people that were, older than 18. I mean, what would you have liked? And I guess going back to Justice Markman's question, I know you haven't developed a record, but what do you want people to do?
Well, I want
Not
people
have sex with underage children.
Well, no, I understand that. What I'm saying is that, what do you want people to do? I guess that's my question. Here you have a situation where that happened, but if the defendant took all these different steps to avoid that, what do you want the public to take away from this?
Well, I don't want the public to take anything away from this case other than that the statute says what it says, it means what it means, it has been constitutional from before this court decided People v. Cash is constitutional now, and if the people believe that there has been the kind of societal change that the defendant says there is, and that this kind of conduct should be subject to certain defenses, they should go to their political elected representatives and try to enact that change. Even the statutory changes that have occurred in a lot of the states, if you look at the chart I tried to put together, that have mistake of age, limited, some of them to under 13, some under 14, some under 15, some under 16, one under 17.
Okay, so
that there's no mistake of age defense under that.
But I guess my point here is that let's take you down the road. Let's go down Woodward from your office to Wayne State. Mm-hmm. And at Wayne State, let's say you have two university freshmen that are at Wayne State. One's 18, one's 17. The 17-year-old says, I'm 18. The 18-year-old does everything he or she can do to avoid falling into this situation. What happens?
Well, they'd have to be younger than that to fall within the statute, under 16.
Okay, but let's just say, but I'm talking about the issues.
One's precocious. She's 15.
Then, again, I would say that what the legislature is saying, not me, what the legislature and the people of the state through its representatives are saying is, if you engage in casual sex with people you don't know well, you are subject to this risk, and it is your responsibility to determine the age of the individual. If society decides, well, that's really too difficult, and we ought to change this, then the political representatives can decide to do that. Even the defendant isn't really saying that this is unconstitutional. He's quibbling about the age. He's saying, well, if it was under 13, it'd be fine. Well, if it's unconstitutional to deny a mistake of age defense. And again, even the statutory changes around the country aren't blanketly establishing mistake of age as a defense. They're limiting it in terms of an age range. And where that should be is a quintessentially legislative choice, if there's to be one. And that's up to them. Again, Cash carefully considered this within 10 years of the enactment of the statutes. The statute was a huge reform brought about in large part by the Michigan Women's Rape Task Force, which a person who was on the court when Cash was decided was a leading member of before she became a judge and didn't say, gee, we're getting it wrong here. I just think the court should simply say this is not our business. This is the political branch's business. The statute is constitutional. Cash was right, and there's no reason to disturb it. Any further questions?
Cash was right, in your view, in saying on the basis of utter silence that the legislature intended in its enactment of the CSC law not to incorporate this mistake of fact defense?
That it's silence coupled with the fact that that was the law already under Gengel. That, yes, that's what they were saying.
Thank you.
I have no.
Okay.
I just have a fun question while you're here. I don't think it's raised by the defendant, but since you're here. Do you think there's a rational basis for the legislature to allow a mistake, to allow a reasonable mistake defense as to the victim's physical or mental incapacity, which they have?
Yes.
But not as to age? Not raised, not.
No.
Just, but we're here and we have a couple more minutes. Is there a rational
Just
basis
for sport.
Well, I would think so. In other words, the legislature is determined to protect minors in this regard. And whether they've become more physically precocious or not, I don't know. If so, I don't think there's any studies that they've become more mentally precocious, so there might be even more reason to protect them now if they're more physically precocious. But as to those who are of age, where you're not engaged in that special protection, then the legislature has determined that if one engages in sexual conduct with them and has no reason to understand this disability is there, then that shouldn't be criminalized. And I think that's a rational choice by the legislature.
That
Thank you very
wasn't
much.
much fun. Thank you. The case is submitted.